Punishment for contravention of Section 73 or Section 76 under the Companies Act, Section 76A. Introduction. Section 76A of the Companies Act addresses the legal repercussions for companies and their officers in cases where there is a violation of the stipulations set forth in Section 73 or Section 76. These sections govern the acceptance and management of public deposits by companies, ensuring that strict compliance is maintained to protect the interests of depositors and uphold the integrity of financial practices within corporate structures. Key provisions of Section 76A. 1. Circumstances leading to punishment. The section outlines specific situations that may lead to punitive actions. If a company either accepts, invites, or allows any other person to accept or invite deposits in a manner that contravenes the regulations established under Section 73 or Section 76, or if it fails to repay the deposits or any accrued interest within the time frames specified in these sections or the associated rules, the company and its officers may face significant penalties. This includes not only the initial obligations related to deposit repayments but also penalties that reflect the seriousness of the contravention. 2. Financial penalties for the company. If a company is found to be in contravention of these provisions, it is required to repay the amount of the deposit or the portion thereof that is owed, along with any interest due. Additionally, the company will incur a fine that is not less than 1 crore rupees or double the amount of the deposit accepted, whichever is lower. However, this fine may extend up to a maximum of 10 crore rupees. This tiered penalty structure serves as a deterrent against non-compliance and emphasizes the importance of adhering to regulatory standards. 3. Punishment for defaulting officers. The section further extends liability to the officers of the company who are in default. Any officer found in violation of the law may face imprisonment for a duration that can extend up to 7 years, along with a financial penalty. The fines for these officers range from a minimum of 25 lakh rupees to a maximum of 2 crore rupees. This aspect underscores the notion of individual accountability within corporate governance, ensuring that those in positions of authority cannot evade responsibility for contraventions. 4. Aggravating factors for liability. There is an additional provision that imposes greater penalties if it is demonstrated that an officer of the company acted knowingly or willfully in contravention of the relevant provisions. If it can be proven that such actions were taken with the intent to deceive the company, its shareholders, depositors, creditors, or tax authorities, the officer may face further actions under Section 447. This provision aims to address fraudulent behavior and reinforce ethical practices in corporate operations.